Cullis signed the scheduling order proposed by Counsel for Union Carbide. In April of 2025, Union Carbide filed various motions for summary judgment and motions for partial summary judgment. And in July of 2025, Union Carbide filed motions in limine, multiple ones. On April 1, 2025, Union Carbide filed a motion to dismiss purportedly pursuant to Rule 12b2 of the North Dakota Rules of Civil Procedure upon alleged lack of personal jurisdiction grounds. Disregarding the fact that North Dakota State District Courts had permissibly exercised general jurisdiction over asbestos product liability actions maintained in this jurisdiction by plaintiffs who do not reside in North Dakota, not many of them, some, and whose previous asbestos exposures occurred in other states. Defendant Union Carbide claims that principles of general as opposed to specific jurisdiction do not permit the plaintiff to maintain his personal injury claims against the above captioned plaintiff in this forum. This at this point brings us to the sort of classic personal jurisdiction case that this is, particularly in the wake of the Mallory decision by the United States Supreme Court. Justice Gorsuch, writing for the Supreme Court in Mallory, articulated the distinctions between general and specific jurisdiction, but specifically where a defendant, in this instance a corporate defendant, has registered with the North Dakota Secretary of State pursuant to North Dakota statutory law as a condition precedent to that defendant or that corporation being able to conduct business here in North Dakota. And there was, from probably 2010 right on through the 2010s, some confusion in the personal jurisdiction decisional law, which actually caused the Pennsylvania Supreme Court to question whether the precedent of Pennsylvania Fire Insurance Company, and these are all cited in our briefs, versus Gold Issue Mining and Milling Company. It's a 1917 case written by Oliver Wendell Holmes, was still viable. And the Supreme Court, United States, emphatically stated that, in fact, that was viable precedent to be followed. Justice Gorsuch, writing for the United States Supreme Court in Mallory, explained as follows: Pennsylvania Fire controls this case. Much like the Missouri law at issue there, Pennsylvania law at issue here provides that an out-of-state corporation may not do business in this Commonwealth until it registers with the Department of State. As part of the registration process, a corporation must identify an office it must continuously maintain in the Commonwealth. Upon completing these requirements, the corporation shall enjoy the same rights and liabilities as a domestic entity and shall be subject to the same liabilities, restrictions, duties, and penalties imposed on domestic entities. Pennsylvania Fire held that suits premised on these grounds do not deny a defendant due process of law. Even Norfolk Southern, that was the other party in Mallory, does not seriously dispute that much. It concedes that it registered to do business in Pennsylvania, just as in this case, Union Carbide did in North Dakota.
But does North Dakota have a similar law as to Mallory?
It does, and we recite those in our brief, Your Honor. I will find those for the court. paragraphs 39, 40, 38, 39, 40, 41 of our opening brief. And I'll specifically refer to those. They're directly comparable. First, in paragraph 38, we refer to North Dakota Century Code, section 10-19.1-132. Subparagraph 2 says, a foreign corporation holding a valid certificate of authority in this state has no greater rights and privileges than a domestic corporation. Certificate of authority does not authorize foreign corporation to exercise any of the powers or purposes that a domestic corporation is forbidden to exercise. And then,
Mr. Thompson, the appellee's brief cites another statute that says the opposite. Says that it doesn't, by itself, registration itself does not create the basis for personal jurisdiction. And I'm looking at your reply brief, and you haven't mentioned that statute, and it's 1001.115.
Sure, and that's a self-serving statute that is state law and has nothing to do with due process. It's the due process analysis that governs general jurisdiction in connection with a registration by a foreign corporation to do business in a particular state. The relevant statutes we refer to beginning at page 18 in paragraph 39 of our brief. Foreign corporation may not transact business in this state or obtain any license or permit required by this state until it has procured a certificate of authority from the Secretary of State. That's exactly the statutory scheme that was at issue in Philadelphia Fire and also which was at issue in Mallory. Paragraph 40. A foreign corporation authorized to transact business in this state shall continuously maintain a registered agent in this state. That is also in confluence with the statutory scheme of Philadelphia Fire and Mallory. Paragraph 41 of our opening brief. North Dakota Century Code 10-19.1-142 provides in relevant part as follows. Transaction of business without a certificate of authority. A foreign corporation transacting business in this state may not maintain any claim, action, or other proceeding in any court of this state until it possesses a certificate of authority. And clearly the reciprocal aspect of that would be to be able to defend an action in this jurisdiction. Subparagraph 3 of 10-19.1-142 says, foreign corporation by transacting business in this state without a certificate of authority appoints the Secretary of State as its agent upon whom any notice, process, or demand may be served. So, in Mallory, Justice Gorsuch referred to the decision in Philadelphia Fire, stating, Missouri Supreme Court issued a thoughtful opinion. Not only did the similar rule apply to transitory actions against individuals, other leading judges, including Judges Learned Hand and Judge Benjamin Cardozo, had reached similar conclusions. Philadelphia Fire controls this case. And I started to read from that particular passage. And the aspect of appointment of a agent for service of process and the requirement of obtaining certification from the Secretary of State of the state in order to do business is the same in Philadelphia Fire and Mallory. And the proceedings below, the facts are identical, essentially identical, operatively identical. Norfolk Southern and Mallory complied with the law for many years, registered to do business, had a certificate of authority to do business, named a commercial registered office, that's the registered agent. And essentially, it's the same thing. And the statute that Your Honor referred to, Chief Justice McEvers, is essentially, well, it is self-serving, but it also says, in and of itself, does not grant personal jurisdiction. But it would be absurd if a state could immunize itself simply from considerations of federal due process by simply enacting a statute like that, which would superintend over federal due process analysis. So, and I'd like to address this before I sit down for my rebuttal later. Argument also was made by the appellee that the long-arm statute did not apply to the plaintiff's claims here. The long-arm statute doesn't need to apply because it's a specific jurisdiction concept. One of the decisions that we cite is Cooper Tire and Rubber versus McCall, rather. It's a 2021 Georgia Supreme Court decision. And it was decided just before the Pennsylvania Supreme Court decided Mallory, and obviously before the U.S. Supreme Court decided Mallory. In the end, in the conclusion of its decision, the Georgia Supreme Court says, conclusion, because the long-arm statute does not apply to an out-of-state corporation that's authorized to do business in Georgia, Cooper Tire is not subject to specific jurisdiction in Georgia. However, because Cooper Tire is registered and authorized to do business in Georgia, and that's all it says, registered and authorized to do business in Georgia, Cooper Tire is currently subject to the general jurisdiction of our courts. Under Klein, that was a predecessor case that relied upon Philadelphia Fire. Klein's general jurisdiction holding, which we have decided to leave in place. And Cooper was addressing the question that had been basically peddled at the time, that Philadelphia Fire was somehow a dead letter. It was no longer to be followed. Cooper Tire answered the question the same way that the U.S. Supreme Court later did in Mallory, saying that Philadelphia Fire was valid precedent, and Philadelphia Fire also did not analytically run afoul of the international shoe analysis. And that was discussed by Justice Gorsuch at more length in his opinion written for the court in Mallory. I hate to leave minutes on the clock, Your Honor, so I'll use my last minute here. Because I found out I lose them if I don't use them now. So.
That's correct.
All right, I didn't know that. Justice Gorsuch talked about international shoe and its interplay with Philadelphia Fire, and how Philadelphia Fire was not inconsistent with international shoe, and that the two precedents could exist side by side and both have vitality in contemporary due process, personal jurisdiction, jurisprudence. I spend the time to talk about the general jurisdiction aspects relative to the certification to do business, the so-called consent jurisdiction issues, because they're spoken of interchangeably with the concept of general jurisdiction. Now, this court can and should find that there has been a waiver of the personal jurisdiction argument, but the more general issue will come up again. We would ask that the court address both issues. even if it decided the question on the basis of a waiver. Thank you.
Mr. McNary?
May it please the Court, Chief Justice, Justices of the Supreme Court, and Counsel. I'm Casey McNary. I practice at the Circlin Law Firm in Fargo, and I'm counsel for Union Carbide in this matter. There's really just one sole issue before the Court, and that's the question of personal jurisdiction in this case. We're asking this Court to affirm the decision of the District Court, which dismissed Union Carbide from the underlying action based on lack of personal jurisdiction. Briefly, the standard of review. For this case, when reviewing personal jurisdiction, of course, the court applies the de novo standard of review to questions, or to legal conclusions, and the clearly erroneous standard to any factual findings that were made below. This court has said that personal jurisdiction determinations require a case-by-case analysis, and they're based very specifically on the facts and circumstances of the underlying case. I do want to point out that the case law is also very clear that once a defendant challenges jurisdiction, that it's up to the plaintiff to establish that jurisdiction does exist. And to do so, the plaintiff just has to establish a prima facie showing of jurisdiction. I don't want to belabor the factual background and the procedure below too much, but I think there's a few points worth touching on in this case. As Mr. Thompson noted in his recitation, there was a prior action involving Union Carbide and a multitude of other asbestos defendants in Cass County District Court that I believe started back in 2021. Now, in full transparency, I was not counsel for Union Carbide initially when that case started. I did not get involved until January of 2024. But that prior case was dismissed on a stipulation for dismissal without prejudice. Just to circumvent any confusion, there is no underlying written agreement. The contract that Mr. Thompson spoke of during his recitation is in fact the stipulation for dismissal without prejudice, which was filed with the district court and ultimately led to Union Carbide's dismissal in that case. That is the contract that was referred to. There was no written agreement signed by Union Carbide in that underlying case. This case was started approximately a month or so after the prior one was dismissed. The difference in this case is rather than there being 20 to 25 of the typical asbestos defendants, there were only 3. It was Union Carbide, Metropolitan Life Insurance, and Western Steel and Plumbing. Union Carbide put in an answer in this case. I believe it's paragraph 61 of that answer contains the lack of personal jurisdiction affirmative defense, which was raised at the outset. As Mr. Thompson alluded to, Union Carbide is a New York corporation. Its principal place of business is in Texas. It is registered here in North Dakota as a foreign corporation, and it has been registered in North Dakota since the 1940s. It does employ a commercial registered agent here. Beyond that, what's in the record before this court are just some general allegations by Mr. Egan as far as jurisdiction goes. A review of his complaint will show that he's generally asserted that the defendants in this case either produced or distributed asbestos-containing materials within North Dakota. There aren't really any specific allegations as to any of the defendants. It's more general allegations about asbestos-containing products. I've referred to this in my brief. I'll state it again here. Mr. Egan did not allege anywhere in his complaint that he lives in North Dakota, that he lived in North Dakota during any period of time. He doesn't allege in his complaint that he ever worked in North Dakota, and he never specifically alleges that he was ever exposed to any asbestos-containing materials or products within North Dakota. So in this case, procedurally, there was some initial delay once the case got started because of a judicial reappointment. Judge McCullough took over this case as he had presided over the last case. And then the district court ordered compliance with some of the newer bankruptcy disclosure statutes, or I'm sorry, asbestos disclosure statutes in North Dakota, some pertaining to bankruptcy and some other disclosure requirements that now exist under North Dakota law. And so it wasn't until December of 2024, several months after the case started, that there was a scheduling order put in place. And then once that scheduling order was in place, and you'd see from reviewing the record, but the district court actually schedules a dispositive motion hearing date within the first scheduling order, so the parties are well aware of when all the dispositive motions will be heard by the court. Union Carbide filed this motion in April of 2025, and then of course complied with the other deadlines as the case unfolded while this motion was pending with the court before it could be heard at the August 18, 2025 hearing. I want to jump into the discussion of general jurisdiction first. Mr. Thompson spent most of his time on that. It's our position that the district court correctly determined that there was no general jurisdiction available here in this case. And so I think the portion of the rule that we're looking at is Rule 4B1. That rule provides that district courts can exercise personal jurisdiction over individuals that are either found within, domiciled in, organized under the laws of, or maintaining a principal place of business within North Dakota. Union Carbide is not domiciled here. It's not organized under North Dakota law. It doesn't have a principal place of business here. And so it was our position below that general jurisdiction didn't apply. As the Chief Justice pointed out during Mr. Thompson's recitation, the district court relied upon section 10-01.1-15 of the Century Code. That statute provides the appointment or maintenance in this state of a registered agent does not by itself create the basis for personal jurisdiction over the represented entity in this state. And that statute, it's our position, is clear that the simple act of registering to transact business here and appointing a commercial registered agent is insufficient. Now, I couldn't find any North Dakota precedent that was directly on point with this issue, but I've cited in my brief the De Leon case out of Montana by the Montana Supreme Court. And one of the reasons why I cited that case is Montana has a very similar, if not the same, statute. And in fact, the Montana Supreme Court talks about how that statute is derived directly from the Model Registered Agents Act, which has been adopted, I think, in 10 jurisdictions, they said at the time of that opinion, North Dakota being one of those. And I thought that court had some an interesting take on the application of that statute. So in that case specifically, the Montana Supreme Court concluded that by consenting to do business within the state, and also the added step of voluntarily conducting some business within Montana is also not sufficient to exercise general jurisdiction. So the plaintiffs in the De Leon case, they had alleged that foreign corporations' compliance with the registration statutes, plus doing some general business equated to consent jurisdiction in that state. The Montana Supreme Court rejected that argument, and it concluded that the jurisdiction limitation in the statute appropriately ensures that service of process and the scope of personal jurisdiction remain separate legal concepts. So simply by maintaining a registered agent to be able to be served within the jurisdiction wasn't the same thing as being subject to personal jurisdiction within the state. And I thought the court had an important quote on page 15 of that opinion. It says, "Subjecting a corporation to general personal jurisdiction everywhere it does business is inconsistent with due process." And so I think looking at that decision and the fact that North Dakota has the same or a substantially similar statute, adopting the reasoning of the Montana Supreme Court in that decision as far as general jurisdiction goes here makes sense. With respect to specific jurisdiction, I'll touch on that briefly. The district court did analyze that issue as well and came to the conclusion that it lacks specific jurisdiction over Union Carbide in this case. There were no, so Rule 4B2 sets out all the different requirements for an exercise of specific jurisdiction. And Mr. Egan didn't allege any of the specific circumstances that are enumerated within that portion of the rule here. And I think just pointing out the lack of allegations in the complaint is important for the analysis. So Mr. Egan, as I mentioned previously, he didn't allege that his claims had any nexus to any of Union Carbide's activities within North Dakota. He didn't specifically allege that Union Carbide had committed a tort against him here. He didn't allege that Union Carbide caused any injury to him while he was within the state of North Dakota. He never alleged that he lived in North Dakota. He never alleged that he worked in North Dakota. And he never alleged that he was exposed to asbestos within our state. So as I read Rule 4B2, there has to be some nexus between the requirement of 4B2 and an exercise of personal jurisdiction and the case specifically before the court, that Mr. Egan would have had to have shown some kind of a connection between his alleged injuries and claims and Union Carbide's activities within our state, and he simply didn't create that connection or make any nexus within his pleading. And so I think when this court, as the district court did, looks at the pleadings, even in the light most favorable to Mr. Egan, I don't think any of the allegations can fairly be read to be construed as him alleging that Union Carbide is subject to jurisdiction here under the specific jurisdiction rule. And I would also point out too that not only was there a lack of information or allegations within the pleading, but even in response to Union Carbide's motion to dismiss, which was the appropriate time for Mr. Egan to demonstrate a prima facie showing of jurisdiction, there wasn't any new material provided to make that nexus. So again, I think when Union Carbide challenged the court's exercise of personal jurisdiction in the underlying case, the burden then shifted to Mr. Egan to demonstrate that jurisdiction was appropriate and did exist, and he failed to do so. We think the pleadings are void of any allegations that demonstrate that Union Carbide should be subject to jurisdiction here in this case, and also Mr. Egan's response to the motion also fails to demonstrate that jurisdiction is appropriate here. I just want to also then address very briefly the waiver argument. I expect we'll hear a bit more from Mr. Thompson on that, but as far as waiver goes, Rule 12B provides that every defense to a claim has to be asserted in either a responsive pleading or raised by motion. And if you look at Rule 12H, it provides that a party waives the defense of lack of personal jurisdiction by failing to either make the defense by motion or include it in a responsive pleading. So it's not both, it's one or the other. And Union Carbide did assert the lack of personal jurisdiction defense in its answer, but even taking it a step further, it did ultimately assert that defense by motion. So Union Carbide did both. So I don't think there's anything in this case that could ever be construed as a waiver of that defense against Union Carbide. And if I circle back to the prior case, as I understand the argument is that because Union Carbide was involved in the litigation of the prior case for upwards of 3 years and didn't assert the motion, or didn't assert the defense by motion in that case, that it somehow waived it going forward. I think the district court nailed this in the order that was issued in deciding the motion, but the district court pointed out that Union Carbide was dismissed in the prior case without prejudice, which is really construed as if that case never happened. It basically renders that case a nullity, and I've cited some case law in my brief that talk about that exact issue. So anytime there's a dismissal without prejudice, it's as if the prior case never existed. So to me, it would be unfair and also improper to look at anything that Union Carbide did in the prior case, did or didn't do, and use that against Union Carbide in this case to say that it somehow waived the defense when it was timely raised in this case and it was brought by motion eventually in this case. So we don't think that there's anything in the record that supports any argument of waiver against Union Carbide. So in conclusion, if there's no questions, we're asking this court to uphold the decision of the district court, which granted Union Carbide's motion to dismiss based upon lack of personal jurisdiction. Mr. Egan failed to make a prima facie showing of jurisdiction against Union Carbide, and Union Carbide did not waive that defense in this case. Thank you.
Thank you, Mr. McNair.
The De Leon case was decided in 2018, at a time when the Pennsylvania Supreme Court, somewhat later, thought Pennsylvania fire no longer was good case law. So De Leon really has no direct, or rather persuasive effect and authority in this case. A 2018 case when the U.S. Supreme Court during the 2010s had questioned in some of its decisions the vitality of general jurisdiction, which was then walked back significantly in Mallory, particularly when the Supreme Court affirmed the vitality of Pennsylvania fire. So, yes, it was another Model Act peddled and adopted, but the point is that at best it has nothing to do with federal due process and the applicability of due process in this setting, as to whether it's the effect of registering to do business in a state essentially permits that entity to be, permits that jurisdiction to have general jurisdiction over that entity. Again, Cooper Tire and Rubber Company, Georgia Supreme Court, 2021, 863 Southeast 2nd, 81. It is in our briefs. Emphasized that that was not a personal jurisdiction or specific personal jurisdiction case. It was a general personal jurisdiction case. We're not saying that this is a specific personal jurisdiction case. This is a general personal jurisdiction case. It's also a waiver case. Justice Jackson, for the Supreme Court in Mallory, talks about waiver by conduct. Waiver can be express and implied. And our position is that by sitting here in North Dakota and litigating in all possible ways for 3 years, and then turning around and saying it violates the due process rights of this defendant to have to defend an identical claim in this case is absurd, respectfully stated. Whether or not the dismissal was with prejudice or without prejudice, as it was, the fact of the matter is that contracts were entered into using this jurisdiction. A deposition taken of the plaintiff in the prior case was used by this defendant in its motion papers seeking dismissal on personal jurisdiction grounds. So that is certainly a beneficial use of prior litigation. So it's not like the litigation never happened. It's making use of it for its own benefit. Now, Justice Jackson, concurring in Mallory, and her concurrence is interesting, and it's interesting that it's a concurrence of Justice Gorsuch's opinion for the court, that waiver, as I said, can be implicit and it can be express. In this case, it's both. It's not express, I guess, in the sense that this defendant has not waived personal jurisdiction as affirmative defense expressly, but it's certainly implicitly done in a very strong and unambiguous manner by this defendant. The discussion of transitory jurisdiction is also undertaken by the U.S. Supreme Court in Mallory. Now, there's nothing wrong with transitory jurisdiction. And the Supreme Court also states in Mallory that specific jurisdiction permits suits that arise out of or relate to a corporate defendant's activities within the forum state. General jurisdiction allows all kinds of suits against a corporation, but only in states where the corporation is incorporated or has its principal place of business or otherwise has legal status in that state. So, in this case, there is no difference in facts, jurisdictional facts, between the statutes that I referred to where a corporation wishing to do business in North Dakota as a condition for being able to do business in North Dakota has to be licensed and certified by the Secretary of State to do business in North Dakota. And in this case, Union Carbide had done so continuously since 1949. With regard to the statute that says, in one of 100-some statutes in the package, registering with the Secretary of State does not, in and of itself, grant personal jurisdiction. Well, we're not saying it does. We're saying that based on the package of statutes, based on the conduct of Union Carbide, being present, conducting business here, not just registering to do business, but conducting business here since 1949, as sanctified by its licensure under North Dakota's licensure statutes. And under the precedent of Mallory, and most of all, Philadelphia Fire, De Leon in Montana probably would have been decided differently today. Mallory didn't exist at that time. And Cooper Tire had not been decided at that point. That was decided in 2021. But it's binding precedent today. Mallory is. And so this court should follow it. And to kind of gauge and assess the extent of what Mallory says, it's important to go back to Mallory's discussion of Philadelphia Fire. It's an insurance company incorporated under the laws of Pennsylvania. Basically, Missouri Supreme Court said, you're licensed to do business here. General jurisdiction can be exercised over you. And as Justice Gorsuch said, Philadelphia Fire controls this case. Much like the Missouri law at issue, Philadelphia law at issue here provides that an out-of-state corporation may not do business in this Commonwealth until it registers with the Department of State. Same thing in North Dakota. On completing these requirements, the corporation shall enjoy the same rights and privileges as the domestic entity. North Dakota, same thing. Statutes, identical, functionally identical. And magic words aren't necessary. As the Supreme Court in Mallory stated in footnote 5, referring to the dissent in that case. The fact that Pennsylvania statute does not use the word consent is of no consequence because there is no requirement in Philadelphia Fire of any magic words being included. It's the function of the registration process that's important. My time has expired, Your Honor. I thank the court for its time today.
Thank you, Mr. Thompson, for your arguments and for yours as well, Mr. McNary. This case will be taken under advisement as all cases are, and court is adjourned until Wednesday, May 13th at 11 a.m.